A very warm good morning to all of you. Dear students, once again, I would like to welcome all of you to a new session of the Civics class. Today, we are continuing with the same chapter from Civics, chapter number 4, the Supreme Court, part 8. Do you remember what we were discussing in the previous class? In the previous class, we were discussing about appellate jurisdiction. And under appellate jurisdiction, we were discussing three important points: that how appellate jurisdiction imply in constitutional cases, civil cases, and criminal cases. That's what we were discussing in the last class. And today we are going to discuss about functions of the Supreme Court, how the Supreme Court function, and how Supreme Court solving different disputes or settlement of disputes by Supreme Court. These are the two different points which we are going to discuss in today's class. Let's move to the class. When we speak about settlement of disputes, first one we need to look into original jurisdiction of the Supreme Court. We have already studied what is meant by original jurisdiction, and different criteria are there, different circumstances are there where the cases will directly go to the Supreme Court. The Supreme Court has the original jurisdiction to settle disputes between the central government and one or more states. Okay, central government in one side and one or more states on the other side. Central government and union territories. In one side there is central government and on the other side union territories. Between different states and union territories. In one side there is a number of states or a single state, and on the other side union territory or number of union territories. All these are coming under original jurisdiction. Original jurisdiction implies in three different categories. First one, enforcement of fundamental rights. So if somebody is violating our fundamental rights, somebody is denying our fundamental rights, we can move to the Supreme Court for the enforcement of fundamental rights. Second one, transfer of cases from high courts. So suppose if there is a transfer of case from the high court to Supreme Court, it also will be coming under the original jurisdiction. Certain terms and conditions are there. We have already seen it in the previous class. Third one, interpretation of the Constitution. Only the Supreme Court has got the power to interpret the Constitution. So these three different circumstances coming under the original jurisdiction. Second one is on appeals. Suppose if there is a case which is being appealed in the Supreme Court, what are the powers of Supreme Court and how they settle the cases? Under this, the first statement says that it deals with appeals which are made to it in respect of its original jurisdiction. It gives its verdict on the interpretation of the Constitution. It also settles interstate or union state disputes. So, first one, if we are going to the Supreme Court with appeal, first of all, make sure that it is coming under original jurisdiction. If it has to come under original jurisdiction, three different criteria are there. First one, it must be something related to fundamental rights, or it is something related to a particular point of law, or third one, it must be something related to the interpretation of the Constitution. Okay, so when we go for appeals, make sure that in that case, these three elements are there. It gives its verdict on the interpretation of the Constitution. So, if that particular case carries a partial consideration from the interpretation of the Constitution, then we can move to the Supreme Court with the appeal. It also settles interstate or union state disputes. And second point says that it hears appeals involving interpretation of the Constitution on civil and criminal cases where special point of law is involved. Okay, so second one says about appeal for on civil and criminal cases. We have seen this particular point in the last class. On civil and criminal cases, if the case has to go to the Supreme Court with appeal, there must be something involved related to the interpretation of the constitution, or a special point of law must be involved in that particular case. Then and there only we can move to the Supreme Court with appeal. And the third point says that it's about this appeal by special leave, a special concern to the appeal, or in a case the Supreme Court can give a special concern. And how it is possible? Article 136 of the Constitution, the Supreme Court can allow leave to appeal against the judgment court of India, which means any court in India, if they are making a judgment and the Supreme Court has the power to allow leave, which means Supreme Court can declare it null and void, or in other words, Supreme Court can declare it as invalid. A special appeal against the judgment of any court of India. So that's a special power given to the Supreme Court by the Constitution, and the particular article is Article 136 of the Constitution. It is a special power which is to be exercised only under exceptional circumstances. So the Supreme Court cannot simply use it every now and then. On special or in certain cases or exceptional circumstances, the Supreme Court has the power to use its special leave, appeal by special leave. The Supreme Court has laid down the principles according to which this power shall be used, and all the powers related to the using of appeal by special leave is given to the Supreme Court. The Supreme Court has laid down the principles according to which this power shall be used. Okay, certain principles are there from the side of Supreme Court if they have to use this particular power, appeal by special leave. So, first one, it is implies in the case of civil cases. Special leave to appeal would not be granted unless there is a question of law or general public interest involved in the civil cases. So, civil case usually will never go to the Supreme Court. It will be getting over by the High Court itself. But there can be rare cases which can go up to Supreme Court. But what is needed? If the Supreme Court has to grant special leave to appeal, would not be granted. Which means if they want to grant, there must be a question of law or general public interest. Or in other words, if there is no question of law or general public interest, it will not be granted. Second one, in criminal cases, the Supreme Court interferes when it is shown that exceptional and special circumstances exist and grave injustice has been done. Suppose in a criminal case, the High Court was not much serious, or because of some carelessness, there can be some injustice to the people who are supposed to get justice. So in such cases, the Supreme Court can interfere in the judgment of the High Court or any other lower courts. So that's why the Supreme Court must feel that it is an exceptional case. It's a special circumstance exists. Okay. So in such cases, the criminal cases can be appealed in the Supreme Court. The Supreme Court could squash the decision of a tribunal when the tribunal has exceeded its jurisdiction or adopted a procedure which runs against the established rules of natural justice. And third point says that the Supreme Court can use this particular power. The Supreme Court can use appeal by special leave. It's a special power given to the Supreme Court. So the Supreme Court can use it. And once they use it, which means they are declaring invalid. Invalid what? The decision made by the subordinate court. Okay. So once they use this appeal by special leave, there are certain criteria. I have already told you about it. We have already seen it. So if there are criteria like if the Supreme Court feels that the lower court has exceeded its jurisdiction, first one, or second one, the lower court has adopted a procedure which runs against the established rules of the natural justice. So they have followed a very different method, and the Supreme Court felt like it was not genuine and it was not apt according to the establish the rules of our constitution. So in such cases, the Supreme Court can use its special power, that is appeal by special leave. So dear students, these are the points I just would like to share with you, and I hope you have got a very clear idea about the points which we have discussed today. So here we are winding up today's class. In the next class, we will be discussing about advisory jurisdiction and revisory jurisdiction. So still we meet in the next class. I would like to sign off. Thank you.